Welcome to Small Practice Support Information Session number 60. In this Law Society of Ireland recording, Emma Jane Williams talks to Justin Purcell and provides an update on anti-money laundering.
You're all very welcome to this small practice information session, AML update. And I'm here with Emma Jane Williams, the AML policy manager from the Law Society. So,
will I fire ahead, Justin?
Yeah, away you go. Emma Jane, thanks very much for joining us today.
Thanks, Justin. It's a great opportunity to be able to talk about all things AML today in the context of small practices. And first of all, just to say that European and Irish anti-money laundering rules, they're a challenge to navigate at the best of times, and certainly considerably amplified challenge by the coronavirus crisis. And AML compliance is by its nature very complex, it's challenging, and it can be overburdensome. And it's especially challenging for sole practitioners and small practices because it's a constantly evolving and growing area in terms of risk and compliance. And it's a struggle experienced by firms of every size around the world. And we are in the Law Society acutely aware of and understand the extent of the burden AML compliance can be, especially for small firms. However, unfortunately, it is a fact that the legal profession across the world is consistently being targeted by money launderers. And it's true to say that small practices are no less exposed than medium to larger firms. In fact, a smaller practice may be especially attractive to a professional money launderer. And that's why we think it's so vital to be able to spot when somebody might be trying to use you to launder money and ensure you have good controls in place. It's really important to not jump to collating your CDD documents where potential risk exists. So hopefully today's seminar will help you on that journey of reducing your firm's exposure to money laundering, enhancing your AML compliance with a particular focus on some simple steps which can be taken by small practices. First, a quick word about the AML resources. It's a priority for us for a long time to be able to ensure smaller practices can keep a pace of AML. And our resources, for example, our free AML training, our infographics, our sample adaptable forms are always designed with smaller practices in mind. So much of our own learning over the years has been informed by queries from smaller practices, and we feed that insight into what we do and the resources that we develop. All the supports are available by accessing www.lawsociety.ie/AML. We're in the process of updating that website at the moment, so do check back for updates. Free AML training is available on Legal Ed Talks, and that takes you through the statutory framework and all of the resources which are available in much greater detail than I could possibly in the 25-30 minutes today. If you are just beginning to look at your AML for the first time, that free AML training hour is a great place to start. Core guidance notes are also available, the 2018 guidance, which supplement the 2010 guidance notes. And these are all designed in a comprehensive FAQ format. Our infographics, well, these visually communicate solicitor AML framework in just 3 pages. And the infographics actually contain hyperlinks, which are designed to help you quickly navigate the 2 core guidance notes. And we recommend taking this bird's eye view of AML provided by the infographics if you're looking at AML for the first time. Our sample adaptable forms, we've designed these to help you comply with your statutory duties. And they were inputted to by the Society's investigating accountants. And we're really grateful for their input because it's good for firms too, from a compliance perspective, that these have been standardized. So you know this is what your supervisor will be looking for. But they're not a checklist, they're not a template. You do have to adapt them to suit your firm's need. We've responded quickly to the coronavirus crisis and developed guidance to ensure AML compliance could continue when you might not have been able to meet your client face-to-face. And all of our resources, they've been hugely successful. Overwhelmingly positive feedback and engagement online indicated by our web statistics, by solicitors, and also external stakeholders too. In the past year, the AML webpage has been visited over 6,000 times with an average download rate of 1,900. The business risk assessments and policy controls and procedures sample adaptable forms remain the most popular of our sample adaptable forms, with over 2,000 downloads each. Nearly 4,000 solicitors have availed of the free AML training on Legal Ed Talks. So please, if you haven't looked at these resources, especially the free AML training, the infographics, the sample adaptable forms, please do check them out. We've designed them to try to reduce what can be a complex journey and to help you reduce your vulnerability to money laundering in as efficient a manner as possible. So another resource that we have is the AML Helpline. And since I joined the Law Society, the AML Helpline has dealt with an increasing number of calls. Some key milestones: in 2009, we would have been taking about 2 to 3 calls every couple of weeks, every couple of months. In 2019, we received at least 4 to 5 a week, sometimes 2 to 3 in a day. In 2020, we would have reached our 1,000th query. And last week, we had 8 inquiries in 1 week. So clearly, this indicates that firms in Ireland are engaged with their AML duties and they want to get the AML piece right. Sole practitioners and small practices make up a significant percentage of inquiries to the AML Helpline. And these hundreds of interactions with small practices also provide us with insight into how small firms interpret their AML duties and what the challenges and issues might be for this sector. So based on these insights, here are my 5 top tips for small practices to become AML ready. Top tip 1, understand how solicitors can be used to launder money. Anyone who has heard me talk about AML before will know I always place a big emphasis on the importance of expanding your knowledge of legal sector risk. I apologize, I'm a bit like a broken record on this one. This is because developing a good understanding of legal sector money laundering risk is vital to adopting the risk-based approach to preventing money laundering and also ensuring effective AML compliance. And this underscores everything. It is the only way to ensure you become AML compliant and reduce your risk. There's no amount of identity verification which will help when there are red flags present. And there are so many resources available. And on this slide, I've just listed these. I won't go through them all today, and certainly one to take away. As a starting place in terms of expanding your knowledge, helpful to know how law firms can be attractive to professional money launderers. Let's look at how lawyers can be used during any of the 3 well-known stages of a typical money laundering cycle. First of all, in terms of placing funds into the legitimate financial system, somebody might arrive at your office with cash. In terms of layering funds into the financial system to move them further away from their original illegal source, you might be instructed perhaps with a fraudulent debt collection. And then in terms of that final step in the cycle of integrating funds to really make them appear legitimate, you might be asked to sell or transfer money or transfer property. And then I say, if there is one place, and I always say this, if there is one place you're going to go to expand your knowledge of legal sector risk, it is the Financial Action Task Force 2013 report on the legal profession. It really is essential reading. It's evidence-based research of the risks and threats to the legal sector. And it would be really good if you could take the time to read the chapters on typologies and red flags if you haven't already done so. On this slide, I've summarized some of the key legal sector red flags and typologies. The headline typologies for me would certainly be the misuse of a client accounts and the purchase of real property. They are the ones that solicitors in Ireland would need to be very aware of as a typology that they might be exposed to. In terms of the red flags that stand out, well, I've tried to categorize them here into different categories of types of risk. So a red flag might arise with regard to your client or source of funds or the choice of solicitor firm or instructions. In terms of client, is there somebody else directing? Are they coming from a high risk country? Are they overly secretive? In terms of source of fund, there's something unusual, something just not sitting right in relation to that with you. Is there disproportionate amounts of private funds? So is there no financing, perhaps from a pillar bank in Ireland, being required? Might there also be high risk countries involved in that? And one to watch out for also is company funding private expenditure. In terms of choice of solicitor or firm, is it at a distance that you're being instructed? Or maybe you might notice refusals by other lawyers in the past. In terms of the instructions, this is one to really keep a close eye on. Is it unusual? Is there inordinate speed or pressure that things need to progress quickly? Does the person need introductions to banks? Is there an absence of supporting documentation? And then one to bear in mind always, is there investment or help from somebody where there's no financial advantage to that person? Are there back-to-back transactions, abandoned transactions, unexplained last-minute changes? Or is litigation perhaps settled a little bit too easily or too quickly? So knowledge of these red flags will reduce your vulnerability to being used to launder money. That is certain. And I can't emphasize enough the value of everyone in a firm, particularly people who have a client-facing role, becoming aware of what the red flags are, so that if they do come across them, you are then given the opportunity to assess further before proceeding. And there's a real opportunity to prevent your firm from being targeted and also save headaches down the road. If you might have preferred, have you known earlier that you would have disengaged. Top tip 2, risk assess before agreeing to act or gathering data. And this top tip is about empowering yourself to be able to spot when somebody might be trying to use you to launder money. Don't jump to thinking AML will be there to help. Don't jump to collating identity documents or bank statements, especially where there might be potential red flags and potential risk there. Don't mistake AML as a way to stay safe. Remember, there is much more to this than keeping your file in order. An AML CDD, ultimately, that's there to prevent you being used to launder money. So don't put the cart before the horse. Timing is also key. Risk assess as early as possible and throughout as needed. Protect yourself and your firm first, and the compliance and CDD piece will look after itself, because once you do risk assess, you'll be able to decide what CDD you need to verify your client's story. It's so much more than the ID documentation. So before taking a case on or proceeding, think about whether there will ever be a combination of documents which will remove the personal risk of committing a substantive offence of money laundering. And sometimes it's not necessarily about being suspicious, but a question of, might the level of AML compliance be a little bit too complex or outside of your firm's expertise? And this approach isn't new. In 2007, we became concerned about the risk of solicitors unwittingly committing substantive offence of money laundering. And it's something which can arise even outside of the AML regulated legal services. And we raised awareness of this risk with solicitors. And also, whenever solicitors contact us, we always recommend assessing by reference to red flags or well-known money laundering indicators of suspicion. And since 2018, that approach, that risk assessment approach, has been placed on a statutory footing, and it requires solicitors to risk assess the AML regulated legal services to determine CDD. And it's an opportunity to use the customer risk assessment, that statutory duty that's there since 2018, as a tool really to help you not go too far down the line in a legal service before thinking about risk and engaging with potential red flags. So there really has been a push away from that tick the box approach to a much more risk-based approach. So the purpose of CDD, that's there to get you to ask questions, to get you to know your client, but you won't know what questions to ask until you risk assess, until you really start to look under the bonnet. But then sometimes the risk assessment itself, well, that's going to be very easy, especially in circumstances where you might have a person with a mortgage with a very small percentage of savings, or perhaps they're selling an existing home. So you understand what's the nature of what you're being instructed to do. But what should you do when you do spot a red flag or multiple red flags? Well, first, focus on deciding whether or not you will provide the legal service and what information you will need to help with that. What's going to make you comfortable to proceed? When risk assessing, it can be really helpful to bear in mind a general rule of thumb from the Financial Action Task Force 2013 report. And that really is, if there are a number of red flags, it's more likely the lawyer should be suspicious. And it really emphasizes the need to consider red flags in context. And in practice, we recommend that you document your thought process around it. So document your analysis. So the Financial Action Task Force report, that general rule of thumb says red flags assist solicitors in applying a risk-based approach to their CDD requirements. of knowing their client, understanding the nature and the purpose of the business relationship, and understanding the source of funds. But if there's a mere presence of a red flag, not necessarily there'll be a suspicion. The solicitor should really ask, is there a legitimate explanation, and document their thought process around that. But if there are a number of red flags, well, that report, that general rule of thumb says that a solicitor would more likely need to have a suspicion. So to help you contextualize red flags when they do arise, we recommend that you might want to start traffic lighting red flags. And I'll talk about here on this slide very quickly a number of different scenarios or case studies for different red flags to try and give you an idea of when you get a grouping of red flags together, the level of risk, and how you might have the same number of flags or information in one scenario, but it might be somewhat more serious in other scenarios. So I've developed a color-coded traffic light system around the scenarios and case studies, suggesting what might be very high risk in red, medium in orange, but with good CDD, you might be able to move into standard, or it might actually move it into more high risk. And obviously the standard risk then in green. So you need to be very, very careful if you are being asked to provide a legal service in circumstances similar to the red coded scenarios here. So looking at the scenarios, scenario one, a new client has reached out by email. It's an instruction for litigation for breach of contract, or perhaps recovery of funds, family law settlement. Copy invoice has been provided, or a settlement agreement has been provided. And it's settling very quickly, relatively quickly, with little or no legal work being done. And there's various countries involved, perhaps. And the thing to note of this is that it is outside of the regulated AML legal service. You wouldn't expect a litigation like this to be vulnerable to money laundering, but it's designed to escape your AML controls that might be there in your firm. So don't realize the importance of remaining alert at all times. And really, it's key to ask if what is trying to be done here, is it a litigation that's actually in reality trying to use you to launder funds? Scenario two, the client resides in the US. An existing client has recommended that they come to your firm. So there's some connection. They're purchasing a holiday home locally. There's no financing required, and bank statements have been provided. But what is unusual is that the bank statements that have been provided are company bank statements, whereas you know that this is a holiday home that's going to be purchased for private use. So some big potential money laundering red flags there, cutting across a number of different categories of risk in terms of client risk, geographic risk potentially, funds entering from outside the EU into a client account, no financing from a pillar bank, it's private financing, and the key one really is something being purchased for a private purpose by a company. So the third red high risk scenario, again, no financing being required, no, from a pillar bank, proposed transfer of funds from a third party, somebody who's going to help with the transaction or volunteering to help. And the bank account they're going to be transferred from is in Uganda. There's a huge sense of urgency to get on with the transaction as quickly as possible. And you haven't met the client yet in person. So you haven't identified or verified their identity. So there's a number of red flags here cutting across all of the risk categories arising, particularly funds from a country. And Uganda is actually one of the countries listed by the European Commission as being especially high risk and vulnerable to money laundering. The fourth scenario, the client resides in the US, there's no financing, no bank account in Ireland, and there's a suggestion that they might need to use the solicitor's client account, and there's family residing locally. So you're more somewhere in between in terms of how you might traffic light that particular scenario. Family reside locally, or perhaps they might be moving to Ireland to work. And use of the solicitor account maybe because they are in the process of opening a bank account in Ireland. There could be a legitimate explanation around things here. The solicitor obviously would need to be very careful around the use of their own bank account, because you can't provide banking services, but take the information on the face of it. Maybe as part of the client establishing, they will open their own bank account. And really ask yourself, would it be normal to purchase a property in a country, move to a country, without also opening bank accounts in that country at the same time. Scenario 5, I'll just move this quickly. The client resides in the EU and they're moving to Ireland. Sorry, I'm on to scenario 6 there. Let me move back to scenario 5 for a second. Scenario 5, it's a nice simple one. The mortgage from a bank in Ireland, so a pillar bank is involved, and there's a reasonable percentage in savings. So you're moving into a space here which most solicitors would be much more comfortable in acting in. Scenario 6, the client resides in the EU, they're moving to Ireland, and it's a sale of a current home and their savings also as well. And an existing client has referred them. You haven't met them in person, so you haven't had a chance to do your identity verification yet. And again, you're moving into a space where people will be more comfortable. Okay, verification hasn't taken place yet, but you're trying to decide whether to provide and reduce risk, and you're going to look at ways to do that. So hopefully these case studies and scenarios will be of help to you in making sure you implement that top tip 2. Make sure you risk assess before you agree to act. Don't put the cart before the horse. Risk assess before agreeing to act, and traffic light any red flags as much as you possibly can.
So Emma-Jane, a quick question there. I'm sorry to interrupt, but what should you do in scenario 2 where simply refuse to act, or should you ask more questions? And then there's another question also, is should you seek further information around the source of funds if they're not available, just about somebody buying a property when there's no red flags? So it's kind of 2 questions there. What to do when all the flags go red, and what to do if you're not sure, but you want to ask more questions.
I think when all the flags are going red, it comes down to that question of, okay, don't be thinking about the AML CDD piece and getting your file in order. Think about the risk that if you proceed, will there ever be enough documentation that will make it okay for you to proceed and safe for you to proceed, because of that risk of the substantive offence of money laundering. So yes, certainly, if you're seeing something, because the offence of money laundering in Ireland is so broad, it encompasses all crime, and the knowledge thresholds are very, very low. That's what you need to put at the forefront of your mind, and certainly be very cautious with anything that is in any of those red scenarios.
Okay, thank you.
Hopefully that answers the 2 questions, I think, does it?
I think so, yes. Yeah. So you just need to make sure that you have a reasonable amount of documentation, or a significant amount of documentation in place to prove the case that you're happy with this. And if not, then you need to do that, or not take on the client.
Not take on, and don't place an over-reliance at the beginning that there will be documentation available that will make it comfortable, because if you're being instructed in something in that red section, there may never be enough documentation, because you're getting into a question of suspicion and have you suspicion with regard to the legality of what you're being asked to participate in. So yeah, be very cautious with anything that is.
Whereas in scenario 5, where you're getting a mortgage from a pillar bank in Ireland, they will have done their due diligence, so that should give you some level of comfort. Is that kind of what you're saying? There's someone else has done.
I would always cautious about somebody else relying on someone else to in terms that they've done their due diligence on it, because there's always the potential that somebody has a bank, for example, might have made a report, but they can't actually tell anyone else that they've made a report. But the thing that's nice about scenario 5 is that it's that more typical thing where a person is purchasing a house, and it's not money that's sitting in a bank account. It's not money that's coming from outside the EU. That's the type of thing that makes it a much more nicer area to be working in. And you certainly go on and do your due diligence, but you don't need to be worrying about there being a risk of money laundering there.
I know we're coming up to about 25 past, so I have just one other question for you on this note. I don't run a client account, so does that mean I don't need to worry about anti-money laundering?
Not necessarily. The have a look at the AML regulated legal services, and yeah, you need to be careful. I mean, the definition of the definitions for the offence of money laundering, they include assets, not just money. So yeah, you do need to be careful if you don't run the client account. It depends on the legal services that you're providing. Have a look at how the statutory AML duty arises. If you're just doing employment law advice, something like that, it may not arise. But obviously, just to stay alert for the scenario one where it might be a litigation or fraudulent litigation.
Thank you.
Will I go on?
Yeah. I know you have a few more slides to get through. So
I'll go through them really quickly. So the next top tip is to engage with the due diligence. So after you've agreed to take on a legal service, so say for example, the scenario 5 or scenario 6 where we traffic lighted, the color is green and it's good to go with standard risk, you do need to ensure that a red flag doesn't arise as you progress. So for example, if funding all of a sudden comes from somewhere that you would expect. So look at the due diligence that follows the initial risk assessment and look out for last minute changes or substitutions. Check back, are there new red flags, and document your thought process. You're not expected to be Sherlock Holmes here, but you do need to interrogate the information that comes back. Maybe there might be more at play here than putting copies of documents on files. Are you happy that things are happening in the way that you originally were instructed? Does the CDD dispel concerns or provide legitimate explanations? And remember also, sometimes professional money launderers will know what to say to get past your onboarding systems, to get you to provide the legal service. And then it's up to whether or not you are engaging with the due diligence that comes in. So it's very much about testing your AML controls that you have in place. The what ifs. So alongside the earlier scenarios, I've included some what ifs just as a way to try and demonstrate the way things can change very quickly. And we'd really recommend ensuring you traffic light red flags throughout and engage with CDD as it comes in. So some ideas here of how things can appear as one thing and then change in situations where you initially had scored it as standard or low risk. So in scenario 4, a client opens a bank account in a member state and there's evidence of a pension lump sum and they're establishing in the member state. So that one we had categorized as potentially amber, but what if you get due diligence information and you get more information and that makes that much more comfortable to act in scenario 5, all of a sudden, this is the one where we really think this is very much a low risk service because they have the mortgage from a bank and there's a reasonable amount of savings in cash. But what if they arrive into your office with the savings, I should say, in cash, that bag of cash that arrives in the office? So all of a sudden that would immediately move that into red, and you would need to be thinking about what to do in that scenario. Scenario 6, what if the funding is transferred from a company? So you thought it was going to be in scenario 6, the sale of current home and savings. But what if that actually becomes more like scenario 2, where it's actually a company that is funding the purchase of private asset? So think very carefully before you continue, and is there a legitimate explanation around what you're being asked to do? Top tip 4, evaluate the current threat to your firm. So this is really the business risk assessments, and it requires firms to take a bird's eye view of risk exposure. And it's a relatively new concept for solicitor AML. It's there in the 2010 guidance, but it's on a statutory footing now since 2018. And it's essentially asking firms to take that global view of where the risk might be. And ultimately, that's something that might help your firm reduce your exposure to being targeted by money launderers. And it's an opportunity also to pick and choose the more high-risk services, perhaps online or non-face-to-face, and decide on a business model level, these may be too high risk or too complex that you don't want to start taking on those services in the first place. There's different ways of going about it. You can start with a blank page, and I've listed different categories that you would really want to be considering. But what I'd really recommend, especially for smaller firms, is to adapt business risk assessment, sample adaptable form. It guides you through all of the issues that you need to consider. So that's top tip number 4.
Just a quick one there on it, Emma Jane. Is it just me as the principal who's responsible, or is it the whole staff who needs to be sort of brought up to speed on this? Would you recommend?
All staff. It's so important, and particularly, I suppose, in your when you have developed your policies, controls, and procedures, that's everyone in the firm understands what they can and can't do and what controls you have in place. So, for example, that where somebody all of a sudden comes in with cash, that they are empowered to say, I'm not allowed to accept that. So yeah, it very much front-facing staff, and everyone does need to know. And the best place to start really is those financial action task force red flags. And certainly the legal ed training that we have is available to everyone in firms. It's not just solicitors. So the fifth top tip is to be strategic. Develop risk-appropriate policies, controls, and procedures to reduce your firm's risk. So once you've assessed in your business risk assessment, then put that into practice in your policies, controls, and procedures. And so there's some very specific statutory duties around what needs to be done in this particular area. There needs to be senior management approval or buy-in, and they need to be kept under review. Which there's an opportunity to determine how you want your firm to deliver anti-money laundering regulated legal services, those ones that are particularly high risk, and an opportunity to take those decisions about whether to provide certain circumstances in your policies, controls, and procedures, so that you're not on the back foot dealing with it where a legal service might have progressed and you would have preferred to have potentially not acted in some scenarios, particularly in the red flag scenarios. You have an opportunity there to outline your controls, the policies, and how risk is going to be mitigated. For example, many firms have policies in their controls and procedures where they won't accept cash, and others have strict controls over the provision of account details for transactions to ensure they're happy with the source of funds before they actually proceed. And there's an opportunity to outline staff responsibilities here as well and ensure that they are followed by staff. So the policies, controls, and procedures, they really are at the heart of the AML framework. So just on this second last slide, I think, yes, I've summarized what those 5 top tips are, another takeaway. And then I suppose in conclusion, just to really remember there's more at stake than compliance failure. The Law Society's investigating accountants, obviously they supervise and enforce AML, but there's always, that ever-present risk of a criminal investigation or warrants for files in your firm. And in that AML regulated space, and there might be a crime fraud exception, and there'd be little, if any, legal professional privilege. So it's so important to document your thought process around red flags if they do arise. The AML helpline, please do get in contact with us, aml@lawsociety.ie. I always try to manage people's expectations because sometimes solicitors ask us, should they make a report in a specific scenario or about the adequacy of documentation or compliance approach in a specific scenario, but we can't answer those questions. We can't make these decisions because it's risk-based and we don't have visibility, and the answer will be different in every scenario. But we really would like to help you in terms of pointing you in the right direction of what guidance would be relevant to the particular query that you have. And hopefully the approach we've discussed today in terms of traffic lighting, the red flags, the free training that on legal ed talks, tips for smaller firms, would be of help to you too.
Listen, Emma Jane, thank you very much for giving us such a succinct and in-depth analysis of what is a very complex and difficult subject matter. So I know that 30 minutes is sometimes it's hard to get it all in at once.
I'm over the 30 minutes. Sorry, my apologies.
No, you're not. You're fine. So we'll be sending out a recording to everyone at the end of the week with a copy of the slides. So we'll have all the information. Unfortunately, these information sessions don't qualify for CPD, so I apologize for that. Next week, we're joined by the Diploma Centre, so we hope you'll all be able to join us for that. Listen, thanks again, Emma Jane, for your time. And I know if anyone needs to contact you for additional information, they can do so on that email address there. We'll send out a copy of the recording later in the week, and we hope you'll all join us next week. Slán agus gur mágat. Thanks, Emma Jane. Bye.